Thank you.
All right, yeah.
SJC-10971, attorney Christine.
Thank you.
All right, Mr. Stanton, please.
Good morning. May it please the Court. My name is James Stanton, and today I represent the appellant, Mr. R. Mr. R. appeals an order vacating a judgment of support, custody, and visitation, and a valid acknowledgement of paternity, which was issued the order was issued without an evidentiary hearing. On behalf of Mr. R., I would ask this Court to reverse the trial court's decision and, in the alternative, remand it back for an evidentiary hearing. This is a very tragic case with these two children. One who's subject to this appeal has lost both a mother and now, as a result of the trial court's ruling, a father.
Let me just ask you a factual question. There's an indication in at least one brief that the current plan is for your client to have custody of Christine?
At the time of the evidentiary hearing,
I know, but I'm just talking about right now.
The current plan is for my department's goal is for my client to have custody and be the permanent resource of Christine.
As a foster parent, or?
Well, no. Well, we don't know the answer to that yet. That in part depends on this ruling. The current status of the matter is Christine is still in a non-adoptive foster care placement, visiting with my client on a regular basis. Her sister, who was the subject of the murder and was kidnapped, has been returned to my client. He has custody. And that matter, and she's been dismissed off the care and protection. He has full custody of her.
He has been shown to be her biological father.
He has been shown to be her biological father. That is correct. Of the new baby.
That's what I mean.
So under the department's, I understand it's their proposed plan, would he be guardian? Would he, I mean, I guess this is the question just asked.
Unfortunately, because of this decision, there's not a clear path to make him the parent. Because of the department's internal regulations, and there was an open case with the child, they can't place her with him. In addition, the child's counsel has opposed placement with him pending the result of this decision. And there is no other identified father. Mr. A, who is the mother's husband, clearly is not the father in this case. And had there been an evidentiary hearing, the validity of that marriage would be
And with respect to
questioned.
the evidentiary hearing, if we were to remand, as you suggest, would that mean with a directive to reopen the 215 Section 6 equity proceeding, or what would the evidentiary hearing be in?
Well, my client never had the opportunity to address the validity of the paternity testing. As I understand that process, the swabs were taken at 2 different times in 2 different locations, and there was never a chain of custody form produced, only the result.
So that's what you want the evidentiary hearing
Well,
on?
in addition, Your Honor, I think the case is saying, particularly Christine, that the biological relationship is not the only consideration in whether you have validated or invalidated an acknowledgement of paternity. In this case, you know, if you look at the acknowledgement, which is part of the appendant's record, Mr. A and Mrs. H and my client lived together. The addresses were the same. Mrs. H did not report Mr. A's address as her address. The goal, and I think Child's Counsel acknowledges in their brief, that the goal of the statute in part is to preserve intact families. In this particular case, the intact family was Mr. R, Mrs. H, and the children.
You raise another point that comes up in the briefs. Would it be an opportunity on remand to look more closely at the fact that the mother and her husband apparently were in a marriage that the federal government, immigration at least, has stated was a sham? And if it were a sham, also on a state level, it could be void, actually. In some jurisdictions, such a marriage is void or voidable, but
If the underlying marriage didn't exist, the acknowledgment of paternity would not be challengeable at this
Right.
point in time.
So is that another issue that
That's
you...
another issue that could be addressed. I mean, Mr. A did try to intervene. That was denied. And actually, when the trial court analyzed the acknowledgment of paternity that's in question here, they found that all the elements were in place, a bit not in the wrong order. Mr. A did sign the denial of paternity.
Yes,
and-
but it was missing her signature on that.
But when you look at the total context, I mean, I think your cases, in many cases, say you have to look at the relationship between the child and the punitive father, and the context in which it was done.
Even if it's out of order, isn't this a lot like Anderson in the sense that all the documents that the mother filed, even if they didn't say, I say he's not, they say, rather, Mr. R is, and that's a lot like Anderson, which was tantamount, at least in that case, to a conclusion that that was paternity. That became a paternity judgment because of the custody and support.
I think it is. And in this, in this case, my client didn't know initially she was married. And she, in the general practice that I have in the district court and in the juvenile court, on a regular basis, you interview clients and say, who do you live with, particularly children? And they say, I live with my mother and father. And then when you ask if there's a marital privilege and you ask for the marriage license, in our society, many cultural beliefs exist, and sometimes people define marriage as living together for an extended period of time. If this court allows this acknowledgement to be attacked and invalidated, I can picture a Chin's child who is 16 or 17 years old, realizing mom may not have been with one partner at time of conception, and then asking the juvenile court to file their own paternity to challenge whether or not her father is actually the father. I mean, it opens a big array of opportunities for children to attack the paternity.
Well, if we agree with you, and let's say we were to remand the case, would Mr. A also be a party?
Mr. A has abandoned the proceedings. He's not responded to any of the briefs. He left the courthouse when the divorce was dismissed, and he learned Mrs. H was deceased, and he hasn't been heard from since, to the best of my knowledge.
How was he allowed to abandon the proceedings? How procedurally did that occur? Since, I mean, basically, it looks like everybody but Mr. R was standing in the shoes of trying to make this child a legal orphan. So if they're trying to make Mr. R not the father, there was actually someone to support, right? That was the other gentleman.
Mr. A never claimed he was the father. In his judgment,
I understand.
in his filing of divorce, he didn't list that he had any children.
Correct.
The department, I believe, published in the Care and Protection in the juvenile
I
court.
was just saying, there are two people here who are in the same position. No DNA connects them to this child.
Correct.
One stands, at least with respect to some parties, in the position of having been the presumptive father because of marriage.
Correct.
And the other one, perhaps the legal father because of acknowledgement.
Correct.
And I guess my question is, if the child and the department are saying your client doesn't have this legal status, then why isn't someone else, or did someone else step in and say, well, we can't have no father. Here, we've got one, because who can provide support, even if he doesn't want to spend time with her.
The reason this decision should be reversed is precisely part of that, what you're saying, is because, the opportunity to identify who the father is gone. The statute, in particularly Section 11, talks about the signing of the voluntary acknowledgement of paternity. And the statute very clearly says, in one of the issues in your amicus request was does the child have standing? I don't believe the child has standing in this particular case, in this particular circumstances, to challenge the acknowledgement of paternity. This 209C is very specific in the various sections about who has standings to bring the petition. And for example, Section 5, when it talks about, if there has not been an acknowledgement, it can be brought by the mother, someone who alleges to be the father, or by a next friend to the child. Section 11 specifically says signatories to the agreement. And it also says that the trial court shall not, hearings regarding the acknowledgement of paternity, the statute is very clear, shall not be permitted. So the question also should exist is whether or not the trial court even had the right to look beyond the 209C judgment of care, custody, and support, and actually look at the underlying adjudication.
So you disagree with the plaintiff and the amicus that a child who is not a party to all this never has a right to challenge that?
I think if you look at Chapter 209C, the specific sections.
Yeah, but what about going outside of 209C?
Well, I think the child has standing when there has not been an adjudication of paternity, when two parents have not been identified. I think, as I read Section 11, once two parents have been identified or a parent has been adjudicated, then.
But the child wasn't a party to that? The child can't bring an equity proceeding?
Well, I don't believe they can. When you look at the cases that talked about back when they brought the paternity issues in civil matters, there's a case where the father and the mother had gone to court. There was a jury trial. The jury trial determined the mother was not the father was not the father. The mother then brought a paternity action. That was dismissed because it had already been decided by the jury. There was no adjudication of a father there. The mother was the only one on the birth certificate. In that case, the court allowed the child to be the plaintiff, and that's consistent with Section 5 because there was no adjudication.
Can I just ask, did you find anywhere a case involving a child who was looking to establish non-paternity? I only could find cases in which a child, in connection with one person ending up not a legal or a putative or a presumptive father, actually establishing paternity. They're always in the context of someone being established. Maybe not, maybe that means somebody else isn't, but it's always both sides.
The cases I have found related to the child being a plaintiff or the child being a party have always occurred in the context of there being no adjudicated father.
Well, couldn't the child in this case bring a petition against the husband or her mother saying that, look, I was born of a marriage, or I was born during a marriage, and I want my father to pay child support, and have him challenge? Couldn't he then challenge his paternity?
The child or
the husband?
Well, the husband's denied paternity. The husband signed an adoption surrender at this point in time. In this particular case.
The question is, why did anybody let him?
Yeah.
Why didn't anyone let him?
Why did they let him?
Why did they let him? Why didn't they require him to take a blood test?
Because I think it was acknowledged that he had not had sexual relations with this woman. I mean, they never.
Doesn't the child have a right to have his blood taken and tested?
I suppose if there was not already an adjudication of paternity, she would. But in this particular case, there was an adjudication of paternity in the acknowledgement. And I think the question has to become, the Judge King at the trial level, said, well, Mr. Rushford, who's the city clerk, obviously had the documents he needed to do to issue the birth certificate. And where does the analysis end? I mean, does the my client wasn't an attorney. My client was not a high school graduate. He had he was at the hospital. They explained if he's the father. He believed he was the father. He was having intercourse with the woman. They lived together. He was there through the whole pregnancy. They lived together post birth of the child. He got custody of the child. I mean, he believed he was the father. When he came to my office a week or 2 or 3 days before this, we went to have the motion hearing, and I showed him the paternity results. He cried. He had no idea he was not the father. And so, I mean, he's operating under that belief that he was. That's the intact family that the statute in Section 1 talks about defining. I mean, the purpose of the statute, according to what the legislation.
But you have the presumption of legitimacy to deal with, don't you?
Well, the question becomes whether there was a marriage, and what is the intact family that's being preserved?
The question was whether there was a marriage?
Well, the marriage in this case was based on.
There was still a legal marriage.
There was a
wasn't
legal
it?
marriage.
Okay. And so there's no question there was a marriage.
But your cases and the cases that exist around these issues look at and presume that a marital family would and the husband in those cases would know that the wife was pregnant, would know that the woman was pregnant. And in this case, not 1 year, not 2 years, not 3 years go by before the husband even learns of the pregnancy.
Well, that's what he claims. I mean, isn't the way to test this is to have him take a blood test?
We could have him take a blood test. I believe, based on his claim and based on what we know from the mother and we know from the record, the DCF record, and we know from my client, that he is not the biological father. When he filed his complaint for divorce, he listed they didn't have any children.
Well, that's not the first time that's happened, where the person has been the father of the child.
Again, I go back to the case, and I think it's the paternity of Cheryl, where it says that biologically, people sign.
Doesn't he? If the child was born while to a woman who was married to a guy, the child is presumed to be the child of the marriage, as I understand it.
That's true.
And I thought that we had case law that allowed a husband in certain circumstances, if he could make out a prima facie case of non-access or something, I forgot what the case law was, or what it says, to allow a husband in certain circumstances to actually have a blood test taken for purposes of whatever the term is, non-acknowledgement or disacknowledgement. There
is in the statute, Section 6, that talks about the fact that they have to sign the voluntary acknowledgement of non-paternity, and that if the husband is not available, then the method to prove paternity is a blood test. But in that, I think those cases assume that A, the woman is married, and B, that the husband is a
So there is a mechanism for the husband to take a blood test to show that he was not the
and they also have the right.
Is there a yes or
yes,
no?
There is a mechanism for the husband to have a blood test. Or in some of the cases in the context of a divorce proceeding, the husband can be adjudicated as not the parent of the child. I mean, there is other mechanisms, but I think it's not void on its face. I think there has to be an evidentiary hearing to determine the circumstances of why this man signed this voluntary acknowledgement of paternity, and whether it was reasonable at the time, and whether it was reasonable for him to know that there was a marriage and that he should have asked another question, and who was responsible for raising that issue to him.
Well, counsel, your time is up.
Thank you, Your Honor.
Yes, sir.
May it please the Court, Brian Pariser on behalf of the Department of Children and Families, and I'll be sharing my time today equally with...
Oh, will you hold on, please, just one moment? We want to get the clock straight. Please start again. Thank you.
Brian Pariser on behalf of the Department of Children and Families, and I'll be sharing my time equally today with my sister, counsel for the child, 7.5 minutes each. May it please the Court, the facts here are fairly straightforward. A man, Mr. R., attempted to have himself assume the mantle of fatherhood. He attempted to do that through a voluntary acknowledgement of parentage. That is provided for by statute if certain conditions are met. And simply put, those conditions were not met in this case.
Now do you agree that if she were not married, he would win?
Well, it would be a very different case, yes. If she were not, well, I suppose that depends on how the order of things occurred, but it would be a very different case. Obviously, if she were not married, then the voluntary acknowledgement of parentage would have been valid when executed by the mother and the putative father, and there would have been no need for further proceedings or a blood test. That blood test now is perhaps a complicating factor in your scenario, Justice Gantz, but it never should have occurred if there were no husband.
Would you say that assume that to be the case? And for reasons, somehow there is a blood test, and which shows that he is not the biological father. Would the child, would the child be foreclosed from challenging that, in your view?
Well, that's really, that case, as I understand the facts put forth, really falls squarely within paternity of Cheryl. In that situation...
Which was a marriage.
No, respectfully, I believe paternity of Cheryl was a man who executed a voluntary...
That's right.
There was no husband, and he subsequently, it was many years later, I believe, had taken a test and found
Yes, but isn't in Cheryl, he was the one that was seeking to undo it, wasn't he?
He was, and he was not permitted to.
Yes, I know. So I'm asking about the child who now knows that this person is not her biological father.
Well, I'm not sure for what reason the child would be doing that, absent some other facts. There are no other, in your scenario, there are no other men in the situation.
I want to know sort of pure legally, could she?
Would she have standing to challenge
Yes.
paternity? I would say that she would have no more or no less standing than any other party would have.
Well, the complicating circumstance in this case, it seems to me, is that Mr. Stanton's client is not operating with a clean slate here. What's in the way, or at least one of the major obstacles, is this child was born to a woman who is married.
Yes.
And it seems to me that the Department could pursue child support against her husband.
Possibly.
Because they acted on this presumption of a marriage in getting the voluntary acknowledgement undone. And why didn't the department pursue child support against the husband and give him the opportunity to ask for a blood test to say, I'm not the father?
Well, if I may, Justice Spina, there wasn't a lengthy period of time that elapsed. Remember, it didn't come to the department's attention but a care and protection was not filed until
July of '09.
July of '09, that's correct. And by the time we were in the probate court, it was only less than a month later, I believe, only a matter of weeks later. So the department had only custody for a few weeks before we were addressing the paternity issue in the probate court.
But the child has a presumptive father.
Yes.
And the department has not pursued support from him.
Not to date, I'm aware of.
Is that unusual in department policy?
It's not unusual. I would submit also, though, if respectfully, if I could come back to the issue at hand, the fact still remains that this is a woman who was married, and the statute required certain things to be done before Mr. R. could complete and finalize his paternity over this child, certainly through a voluntary acknowledgement. Those things were never done. So for
we will assume for the moment that there's a valid marriage, but there are suggestions that there was non-access, that, she was, maybe it isn't valid if there was an immigration proceeding and it was a sham marriage. But let's take it from that point of view. And you said, well, there wouldn't be any reason for a child in that position to, challenge paternity, right? And why is it true in this case? And what I'm really asking, really, when you compare a child in either a presumptive marriage who really has a father who's really not the biological father, or in this circumstance where the guy comes in because he thinks he has this girlfriend, in fact, he has a second child, there's a sibling, right? I don't understand the policy reasons, if the policy in the first place is support, and all the cases speak either of support or of inheritance. There probably should be another discussion, which is in the mix, best interest beyond support and inheritance, as long as there's somebody who's able to do that and not negligent. What is really the policy behind permitting a child to intervene in order to make herself a legal orphan, either in the case of a marriage or in this case? What policy supports that?
Well,
I don't see it in the legislative policy because that's support.
2 points, Your Honor. Firstly, while I know there have been allusions to the question of the validity of marriage, I would hasten to add that there is nothing in this record that casts any question as to the validity of this marriage.
There wasn't really a hearing and the gentleman's gone and you allowed him to, get rid of his obligations legally by saying he's no longer the father, she's up for adoption. So we don't know because there wasn't a hearing.
But there are no facts in the record that call into question the validity of this marriage. That's the first point I just want to make to clarify that. I'm unaware of anything in the record.
I thought the non-access would have been at least one.
I don't believe that's in the record. I could be mistaken. But to go to the larger point, in this case, the child did not make herself an orphan. The child challenged the paternity, asked to have an invalid voluntary acknowledgement declared just that, invalid and null, which would mean that the wife's husband becomes the legal father, the presumptive legal father. She did not make herself an orphan. Her motion merely kicked out of the box, as you will, a man who was never the father of this child, therefore reinstating what should have been the case in the first place, that the husband in the marriage was the presumed father.
Biologically, in any case, there are other definitions of father, but at least biologically.
Well, no. There are many definitions of father, but for the purposes of the law, the husband is presumed to be the father. The presumption of paternity is enshrined in General Law 209C, and by allowing this voluntary acknowledgement, or even allowing credence to the fact that maybe you can make a claim of paternity based on an invalid voluntary acknowledgement, you've undercut that. In this case, All that the child did was reinstate what should have been the case from the beginning.
May I ask you, I'm just curious, so let's assume we agree with you, and so we reinstate the absent husband as the child's father. Who will care for the child for the next 16 years? Who will pay the support for the child?
Respectfully, Your Honor, that question is not before the court today.
But answer it for me.
That question will be decided by the juvenile court judge who's currently sitting on the care and protection matter. The juvenile court judge has many dispositions open to her.
What are the options that the court would have?
The department currently has custody, obviously. Any number of outcomes could arrive from the care and protection proceeding.
Well, the husband's he's not available.
He has signed a surrender, the husband. So he himself has absented himself from those proceedings. Mr. R. could still continue to be the caretaker. He could be the guard, as the department puts forth in its brief, he could be appointed as the guardian of this child. He could even petition to adopt this child. He could ask to be the foster parent of this child.
Why couldn't he seek under, is there anything in 215.6 that wouldn't allow him to proceed under that? An equity petition?
Well, he potentially could seek equity in some other, no, because his relief, I would submit, is still before the juvenile court that's charged with determining the proper permanent plan for this child. He can't seek paternity adjudication under 215 under equity because no longer, now that he is not in fact the biological father of the child.
Wait, could we just stop there? You're saying no longer in fact. Well, first of all, we could say that we should undo it, but no longer in fact. Well, that's usually not a concern of the department in these cases, whether in fact. You don't require blood tests. In fact, after the fact, you don't allow them. Or DNA. I mean, you know, paternity testing.
After a valid voluntary acknowledgement has been executed, paternity tests are not necessary because that has the force of a judgment.
So if we said that all the pieces are in play, they just were out of order, but that's okay because they're really all there. The husband has said it's not his. The mother has indicated that, you know, this is the father, and all those pieces are there. You don't normally look under to see, well, really, you better show me, or we want to know for sure, right? Normally that would be not done.
It might be if all the pieces were in play, but the department doesn't submit that all the pieces were in play. It is a small but significant fact that the mother never signed the denial of paternity with her husband. That is statutorily required. And even though I understand one might wish to say, well, implicitly by signing a voluntary acknowledgement, she's declared that Mr. R is the father and not her husband, if that were necessary in itself, then I could not think of a reason that the legislature would require expressly that she sign the denial
They
with the
mostly
husband.
don't anticipate she's going to die, probably. I mean, it's unusual. It's an unusual set of circumstances, and so we're trying to look to where the policy might fit and what it means. I guess that's my question. So I don't want to interrupt you, but you were saying that he couldn't come back now because he's in fact not, although, so my question was,
as a petition
it
for
doesn't
equity,
really matters much.
I'm sorry, Your Honor. Yes. I was just referring to this Court's decision in CC versus AB. Because paternity may be established through a petition in equity, I believe that's what Justice Botsford's question was going to, that still has two requirements. The requirement, one, that he in fact be the biological father of the child, and two, that he be able to establish a substantial relationship with the child. Now, he may very well be able to establish a substantial relationship with the child. The department doesn't dispute that point here. But the fact that he has determined by genetic marker testing to not be the biological father of the child eliminates him from consideration. I believe CM versus PR, cited in the department's brief, says that the fact that a man is not the child cannot be declared the father when he is not in fact the father, and I paraphrase.
All right, we'll have to leave it there. Thank you, sir.
Thank you.
Good morning, Your Honors. Dorothy Starro for Christine, who is 3 going on 4 now.
Why wasn't a guardian ad litem appointed in this case?
No one asked for one to begin with, Your Honor.
I think there should have been one?
No, I don't. I think in the practice that I've observed, and this is just my observation, it's very rare for guardian ad litems to be appointed when there's counsel for the child in the probate court. Of course, counsel for the child here had an obligation to make a thorough review of the facts and to make a substituted judgment because her client was not of an age where she could articulate her position. So the court needs to understand.
You're saying that the counsel in this case makes the substituted judgment, not the GAL?
Absolutely. And that's what our performance standards, and that's what the Code of Professional Responsibility requires under 1.14.
And the substituted judgment goes only to legal status but not best interests in this case? I don't.
It's the way we define it, Judge, or the way you've defined it, is that counsel, after making a thorough review, decides what this child, what Christine, not other children, but what Christine would choose were she able to articulate her position based on all the facts that are there. And of course, those facts aren't before the court, so you don't know why this counsel took this position. But I think what is in the argument before the court, Mr. R argues that there's this substantial relationship, that it's a parent-child relationship. He implies it's a de facto parent. At page 107 and I think 102 of the transcript, you hear both the department and child's counsel questioning that, and in fact saying maybe there isn't this attachment that Mr. R has said. That, of course, isn't what motivates or what the probate court needs to worry about. The probate court needs to decide whether, in fact, this man is the legal father of this child. We know he's not the biological father. And so the probate court's going to decide if he's the legal father. If he's not the legal father, this has dramatic impact on Christine. Because if he's not the legal father, then this child's in juvenile court, and the juvenile court is going to weigh among the potential options for this child. We have adoption of Hugo, which says the court will give no artificial weight to any plan for this child, but it will determine which of the available options is the best place for this child to grow up. So to the question, where is she going to grow up? The juvenile court is going to decide that, but it's not going to decide it by giving Mr. R default status. If you overturn the probate court and he becomes the default dad, then he has custody of Christine unless there's clear and convincing evidence that he's unfit.
Just ask a question. By the way, this child is almost 5, not almost 3. She was born in 07, right?
07.
Is 04?
No. She's almost 4. She's born in November of 07.
November 21st, 07.
So she's 4, almost.
Almost 4,
Just
exactly.
next month, okay.
That's right. That's right. I thought I did that right.
I'm trying to understand what your concern is. What if it comes up accidentally and not in this kind of case, and she's at the doctor's, and then the doctor sees, wait a minute, they take her to the doctor, you're not a match here, whatever reason. Does the department come in those circumstances? I mean, what circumstances that might bring to someone's attention that the father who acknowledged paternity, because you can do it in another way, right? Does it come up in any other circumstances? Or, I mean, I'm just trying to understand the policy when it becomes so important that the acknowledged father is, in fact, not the biological father, which seems important here.
I think that's right, Judge. I think that there are situations, certainly, where a child finds out later in life that the person that's been holding himself out to be the parent is not the parent. And I think that there's discussion in some of the literature about how important it is for children to have a accurate determination of paternity, or at least to know who their biological parent is.
At least to know, certainly. And,
Yeah.
you buy sperm, maybe, or you don't, or whatever.
One of the concerns, of course, if Mr. R becomes the legal father, then everybody stops looking for the bio father. Whereas if this goes back to the juvenile court and Mr. R is not the father, he stands in the same position as everybody else.
Is there any indication in this case, any at all, that the biological father is anywhere on anybody's radar screen?
We're still looking.
I'm not trial counsel, but my understanding is that Mr. R. actually named a potential person, but I'm not sure that they've been able to find that person.
I mean, that's
I
just-
don't
that's-
know if-
That's theoretical nothing in this case, isn't it?
It is, Judge. What's more important to Christine is whether this person that is not her father gets the right to assert the rights of a father in a juvenile court. Because if he does, then he gets custody of her, even if he's not the best placement for her, even if there's somebody she has a tighter relationship with, even if there's somebody that is a de facto parent to her. He wins because you've overturned the probate court. So this trial counsel looked at the facts, and once it came out 6 months after the first hearing, that in fact he wasn't the bio
This trial
father.
counsel meaning you? Is that what you're saying?
Well, I'm appellate counsel, but yes, trial counsel for my client,
Ms. Winchester.
Miss Winchester,
Yes.
would have looked at all the facts that she knew. She would have had a court investigator's report. She would have had a volume of facts that left her the opportunity to make a substituted judgment. And she came into that court and she said, this child does not want this Mr. R to be found to be her legal father, because he's not her biological father. Mr. R makes much of the fact that the child is being orphaned by what the probate court has done, and that's just not the truth. The child had a mother, the mother died. The child had a legal father. It was Mr. A. That's what our law says.
But isn't it, didn't I just hear from Mr. Parieser that in the juvenile court, he's been allowed to disappear?
Well, that's something that the department and DOR often do, but in point of fact, under adoption of Marlene, until my client is adopted, they have the right to seek financial support from Mr. A.
But in terms of,
Because he's filed a surrender, but a surrender does not cut off the obligation of child support. He's saying, I don't want to be the father. Our law says he can do that. We don't force people to be parents. We think it's better that the juvenile court find somebody who wants to be a parent. I want to correct just a few things on the record that were brought up that really aren't on the record, but given that you heard evidence about them, I want the court to be sure to understand that my understanding is Mr. R hasn't visited this child since June of this year. I think that it's important to understand that it's never been enough, even if he did prove that he was the de facto dad, which he didn't. And even if the probate court had made a finding, if you sent it back for more hearings to find out, is he the de facto dad? Even if you found that, under CM versus PR, that wouldn't be enough. Because what this court has repeatedly said is you can't establish parental rights by being a de facto parent or by having a substantial relationship. If you want those parental rights and you're not related, the way you do that is through adoption. Now, Mr. R has filed a petition for guardianship. He can pursue that.
juvenile court? Where's he filed?
I believe it was in juvenile court.
Can I just ask one quick question?
Actually, I may be wrong about that. I'm
It
not
doesn't
clear.
matter, so you corrected me, the child's going to be 4. Does it matter if the child's going to be 12 and they live together? Does it matter at all? And these facts come up then?
Where I think it matters, Judge, is
There are other children
when
out there
there's a
presumably in this
12-year-old.
circumstance.
When I represent a 12-year-old,
Or 10-year-old.
if the 10-year-old, you're getting harder. When I
I want to
represent
make
a
it hard, so
12-year-old,
make it 10.
when I represent a 12-year-old, usually they can tell me what they want.
Make it 10. You know
So
what I'm trying to say
10-year-old,
here.
we're on the, as you get younger, and it's harder for them to express their preference, it's all part of what the substituted judgment is. And when I look at substituted judgment, I'm looking at what's this child's relationship with this
So
person.
you really are saying more than biology was at play here.
Yes.
The substitute, that's really what I hadn't heard you say before. when I was asking the question. It is more than, so if it's 5 years with Mr. R instead of, maybe that would make a difference.
That's right. It would definitely.
You do think it has to be more than about biology.
It's more than about biology, and it's more than about just time.
And so
It's
if-
about relationships and whether they relate that
And if there'd been a good
way.
relationship after 5 years, and the child said, gee, I'm going to let this go, then it would be okay? Then he's actually the legal father now? She's never
Then the
challenged.
child would not challenge it. That's right.
Does it make the legal status better because she doesn't challenge it?
That's a very difficult question, because I think this goes to the question of whether it's void ab initio. And that, I think that you could rule that the child has standing here to challenge it, that having challenged it, she's shown that it was invalid, and that would be a very narrow ruling. I think you also could rule that a critical piece of this acknowledgement was missing. Part of the statute requires a notary. If Mom and Mr. R had signed the acknowledgement but not had it notarized, we wouldn't be here. No one would be saying, well, maybe we should give it effect anyway. It was a mistake. Because it's a statutory process, you have to follow the statute. You're conferring the rights of parenthood, which are much more than the obligation of support. They're the who's going to raise this child questions.
Counsel, we're going to have to leave it there.
Thank you, Judge.
Thank you very much. All right, we'll take a break.
All right, please.